Berkey, which actually included the case of a gentleman by the name of Chakrabarty, and you might be familiar with the case of Diamond versus Chakrabarty. What Judge Risch wrote about what Justice Stevens said is, when one only has compliance with 101 to consider, the sole question, aside from utility, is whether the invention falls into a named category, not whether it's patentable. Falling into a category does not involve considerations of novelty or non-obviousness, and only those two considerations involve comparison with prior art or inquiry as to whether all or any part of the invention is in or is not in, or assumed to be in, the prior art or the public domain. Prior art is irrelevant to the determination of statutory subject matter under Section 101. An invention can be statutory subject matter and be 100% old, devoid of any utility, or entirely obvious. This is our understanding of the statute and the basis on which we proceed. And if we look at what the court has told us, even now in Bilski, it's still saying, well, you need to decide, is this an abstract idea? The problem Bilski had, and the problem that patent prosecution people have, is that the Patent Office, in rejecting on Bilski alone, or rejecting on 101 alone, did not give any consideration to whether the invention was novel or non-obvious. And everybody agreed that that patent application, had it been examined on those merits, would have gone down in flames. Case would have never gotten to the court. So I think, in conclusion on my, in fact, one of the problems we have, and to quote one of the questions or statements that Justice Breyer brought up during the argument, he asked one of the parties, do you think that the framers would have wanted to require anyone successful in this great, vast, new continent, because he thinks of something new, to have to run to Washington and force any possible competitor to do a search and then stop the wheels of progress unless they get permission? Well, I think they would. I think that the founders intended that. They put a patent system in place. It was to protect inventors and to promote science. And so I think what we should have seen at the end of this case is, you can leave us with the fact that abstract ideas aren't patentable. But if you do, what the court should have told Congress is, and the people, is what they ended up telling us at the end of the Sony Betamax case. To quote Judge Stevens in that situation, he said, it may well be that Congress will take a fresh look at this new technology, just as it so often has examined other innovations in the past. But it's not our job to apply laws that have not yet been written, applying the copyright statute as it now reads to the facts. And then he says, you know, we decide this. Basically, if you don't like it, go to Congress and get it fixed. And in the Bilski case, you know, again, the statute doesn't say anything about business methods not being patentable. This case should have been a lot easier to decide. It was argued at the very beginning of the term. It was the absolute last case to come out of the court. And there's really very little reason why that should be the case.
Well, my job's easy because I actually agree with almost all of that. And I don't know if you take questions after you do that. So I'll be very brief. I'll add three kind of interesting, funny tidbits. Number one, it is true that the Secretary of State and the Attorney General were initial patent examiners. That lasted all 3 years. It's at 1793, they said that's enough. And there weren't even that many patents, but they're like, yeah, this is not working for us. So Thomas Jefferson wanted the job, but not so much later. being a long trend of people not interested in patents. Number two, it is true, and one point Professor makes that I think is very good is the court says abstract ideas are unpatentable, and they leave it at that. And the interesting thing is that's both a very broad ruling and a very narrow one. It's broad to the extent that anything could be an abstract idea, or anything could be a non-abstract idea. It depends on how you look at it, especially with the post-solution activity. But on the other hand, it is a good ruling because it doesn't categorically restrict business methods. It doesn't categorically restrict software. And in that sense, the court was very reluctant to dive in and try and make policy. And in essence, go talk to Congress. And one of my favorite lines from the oral argument was where the solicitor, Deputy Solicitor General, who was arguing the case, said, you know what, we know this is a tough case. If you recall, we recommended that you not grant cert, which the solicitor did. And Justice Kennedy said, you were afraid we'd screw it up. You know, the whole court laughed, and the solicitor was like, no, 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 we just thought it wasn't the appropriate vehicle, you know, when lawyers speak for, we were afraid you were going to screw it up. And the court knew that, and if you read the opinion, it makes very clear they were concerned about that. They did not want to mess things up in the way that Parker versus Fluke kind of did. And then the final note is, it's still very tough. I thought one of the funniest yet hardest questions asked was by Justice Breyer. You mentioned what he said at the oral argument reminded me of this. He said, I've got a new, you know, back when I was teaching, I had a new method that kept my students from falling asleep when I taught antitrust. Got a patent on that. And, you know, the counsel for Bilski was, sure, I don't see why not, but obviously something seems wrong with getting a patent on that. And that is the difficult question to answer going forward. And unfortunately, it's unclear how we should answer that. So I will leave it at that and see if anyone has any questions.
All right. Con Chipotle, lo tengo todo. I'm sure some of you are agreeing with me right now. I guess we'll open up the floor for questions. And realize that the topic matter is a little bit more technical, but please don't be shy.
Feels like class.
Yeah, that's true. Someone's got a question.
That's not specific after.
All right. Well, Professor Grant, I guess I have a question for you. Well, you both mentioned that Thomas Jefferson was initially on the patent team, and he was on board with a lot of stuff. Did he have any reservations about that later on, or was he always, you know, throughout his life, did he see patents as a necessary thing, I guess, to maintain scientific advancement?
Thomas Jefferson was really quite ambivalent on patents. Even though he was an inventor himself, he never went to the patent office and filed a patent application. To this date, there's only one president of the United States who has a patent, and that's Abraham Lincoln. However, Jefferson was involved, he wanted to be involved in, as Professor Risch quite correctly points out, he decided after 3 years that not only was examining the patent applications not a good idea for 3 officers of the government, but it wasn't even worth starting a patent office at that point because U.S. Patent Office really doesn't get organized in an examination mode until 1836.
Yeah, I would add, I think Jefferson was in the kind of ideas want to be free camp. I think he saw patents as a necessary evil, but would prefer not to have them as strong as they were. And in fact, one of my colleagues who was also affiliated with the Federalist Society has an article in the Cornell Law Review saying, it's titled, "Who Cares What Jefferson Thought?" And goes through the history of intellectual property and how Jefferson's ideas want to be free free idea is kind of overrated, given policy.
Questions? Yes.
How does this ruling affect, like economically change from more of an industrial manufacturing type economy to, I mean, really an idea-based service economy? When most Americans have jobs that are related more to like improving process and that sort of thing, kind of like that, those abstract ideas that they just don't count anymore. How does it affect us long term as far as those changes we're going through as a country?
Well, I think that's a great question. I mean, the people who look backward and say, well, in the past, business methods weren't really patented, and therefore we shouldn't do it in the future, they're missing something, which is they weren't patented in the past because they weren't as important in the past, or they couldn't be done in the past, and now they can. So, arguably, you want to have incentives to create methods of doing business that are more efficient. Now, on the downside of that, policy-wise, is those things move very quickly, and patents have a 20-year term. And so by the time the patent expires, maybe the value of whatever the improvement isn't that helpful for the public anymore. I think it's a double-edged sword. I think it's a very complex question, but I think it's the right question to be asking, which is, as we move to a society that's not as industrial, how do we keep people incentivized to create better ways of doing things?
To that, I would add that outside the United States, most patent systems do not give much in the way of protection to software. And, in fact, business methods are basically unpatentable anyplace. And as a result, AT&T a few years ago had to sue Microsoft in a case that went to the Supreme Court because a disk that contained software used to program computers in the United States was deemed to be an infringement when Microsoft put software on their computers. They were trying to attack the sales that Microsoft was making in Europe because it simply was not protected by patent. AT&T's technology was not protected by patents in Europe. And if you look around, I think the primary places that are producing software in the world right now is the United States.
Other questions? Yes.
Is there any way to predict how this might be different with Elaine Kagan on the board instead of Justice Stevens?
I would say it's, I think I made a prediction in my Supreme Court review article. Kagan is going to fall in the information wants to be free kind of ban business methods, but not as strongly as Stevens. So my view is if you wanted the court to get rid of business methods patents, Bilski was the last best chance for a while because Kagan is not going further than Stevens on that, and she's not going to be a leader in that. So, I don't think it changes much, but it's not going to get any easier to lose a bar such thing.
I guess my comment on that would be the difference on the court right now, maybe the absence of Stevens rather than the addition of Kagan, because you could have put a lot of people in there, and you've put the Parker versus Fluke case, which I told you how Judge Risch thought about it. You put it in more danger because of being literally overturned. Because I don't think as long as Justice Stevens was on the court, they were going to overturn Parker versus Fluke.
Right. I'll add to that. Parker versus Fluke is a terrible decision. Generally, academics hate it, practitioners hate it, everybody hates it. And in our amicus brief, our first draft, we really went after it. And it was terrible, removed by Diamond versus Deere, etc. And one of my colleagues, who clerked for Stevens, said, "Yeah, you got to take that out. You can't do that because there's no way while Stevens is on the court there's no ruling." So we had to kind of tweak it to say that Parker versus Fluke was clarified by later cases rather than overruled because they were. So yeah, I agree with that. I mean, Stevens being gone is the most important feature. It's more important than who replaced him, although it's still going to be 5-4 with the person who replaced him in this case. Although it's unclear how she feels about it. She might come in being heavily pro-IP. I mean, she started her career in Chicago. So